Hi, and welcome to this episode of Beyond the Gavel. Today I'm joined by a solicitor who represents the next generation of leadership in the clinical negligence practice, someone who combines a modern collaborative mindset with a clear commitment to professional standards and care. Mark Thomason, at the moment, is head of personal injury at Optimal Solicitors and chair of the Association of Personal Injury Lawyers Future Leaders Community. His career reflects a steady and purposeful rise through the profession, as we'll hear going through, grounded in serious injury and clinical negligence work as well as the personal injury side, and shaped by a focus on developing both people and processes. He contributes to a model that blends technology with genuine human engagement, with an increasing emphasis now on the rigor and early case analysis in clinical negligence as well as personal injury. He's well placed to speak on the realities facing claimant lawyers today, from managing expectations and evidence to building resilient teams in a challenging legal environment. So, Mark, thank you so much for joining me today, and it's a pleasure to have you on the program.
Thank you. Thank you very much for having me.
Yeah, great. Give us a little bit about your background and how you got to where you are at the moment.
It's quite a convoluted journey, to be honest. I originally started way back when in terms of getting a law degree. Wasn't sure if I wanted to actually practice in law. So I worked for an engineering firm for a year and then got a part-time job at a criminal firm, which I worked at for about a year as a trainee. And then unfortunately that firm no longer exists. They went under, so I had to find another role, which was at a RTA firm who were moving into ClinNeg, and they offered me a training contract with an opportunity to get into clinical negligence, which I felt at the time was the right thing to do for the way the market was going. So I embarked on that, and then from there, I've never really kind of looked back in terms of practice area. So I've practiced predominantly in clinical negligence my entire career from then. And then more recently, I've started to get involved in the operational management of how departments work. And over time, that's kind of where I've really found my interest lies, to be honest, is kind of moving away from casework. And that's something that I didn't expect, but it's something that definitely happened over the course of my own development as a solicitor.
That's very important. I mean, how we've grown. All I can tell people joining today is the job you're going to be doing in 20 years' time isn't the job you started with and what you thought you were.
Yeah.
Once, when I was a consultant, people asked me, "What did you think? When you made it?" I said, "I thought when I made it, I wish people had told me earlier that there was nothing there, because once you get there, it's then what, and you've got to start moving, and you've done that." As a generality, without being specific, was there a reason that a particular company went under?
Um,
Just
so
in
in
general.
respect, yeah, just general. I mean, criminal law. If you've ever read any of the work by I think there's a barrister who a secret barrister. If you ever read anything by that individual, you will see how difficult it is to survive as a criminal lawyer. The clients typically won't be able to pay anything, and it's a very difficult practice area to be successful in. And in that area where I worked in the region, there is a lot of criminal practices around that area, and it was just a competition thing, just not really able to survive.
But that's a very important point. And here we're talking to younger people or people who are within firms. Some of them don't get it that, that they're fee earners, not fee takers. And
Yeah.
that we have to understand it's a business. And there's one side where you're looking at quality, and the other side you have to look at sustainability. So how has that experience molded you now that you're going into management, into thinking about how do we keep this firm afloat?
So one thing that I would always notice, or one thing I feel I have noticed throughout my own practice, is that you tend to, and this is very broadly speaking, you tend to have two different types of lawyers. There are lawyers who are very, very good at fee earning, and their motivation is to help clients. Their motivation is, they got into law because this is a passion for them. This is something that they wish to do. They want to be on the client side, and they embody, that real principle of being there for the public. You then have what I would say I probably fit into, which is the more commercially minded individuals who understand that what we do has to be profitable, so that we can be a facility for those who may have a bit more passion than we do, so that they are able to use the law firm in order to, be there for clients. You still need to make money. You still need to generate fees. And as cold-hearted as that can sound sometimes, you need an individual who is willing to say, well, hang on, is this profitable? Can we make money through this? Because if we can't make what we're doing sustainable, then the individuals whose main interest is helping people, they can't provide that service because there isn't a firm for them to work at.
Exactly. It's all very well, give, but you've got to understand it's give and take. You've got to be able to keep sustainability. So how do you set about teaching? I mean, whether they are so passionate about what they're doing or not, they've still got to learn the hard lesson that you've got to make money. It's a business, that you don't want to make vast profits. I get it. But you've got to make a profit. You've got to pay for the lights to be on. You've got to pay for your staff. So how do you put this in, especially in your role with the Association of Personal Injury Lawyers, where you're leading leadership in these new people coming in? How do you set about teaching them that there's the passion, but there's the practice?
I think that there's two different kind of main ways that I would be looking at this. The first is with the more senior, experienced lawyers that you have in your team, which is you try and get them to understand that case cycles exist. So the length of the time that the case is going to take, and you actively try and encourage them to think about, well, when will that case settle? How long is it going to take you to get there? Can you obtain an interim payment? Are you able to hit a target? So, I mean, targets are a very sort of, traditional thing in the legal world. So it's not, you're not sort of teaching them anything too new, but it's just trying to understand the commerciality of what they're doing. When it comes to the more junior staff and the people who are embarking within this sector, I always try and think of it as you are showing them what value they bring to the process and how their work impacts the whole sort of state of the firm. So one example that we tend to use is when we take a case on, there's you don't simply, with a lot of law firms, you don't simply, someone doesn't tend to just knock on your door. It's very, very rare that people will come to you, and if you have that marketing ability like some firms do, then brilliant, through reputation. But there's a lot of firms out there who have to actively purchase work from advertising companies and such like this. And so if you're able to say to an individual who is just starting out, look, there is a cost associated with bringing that work in. We will make so many pounds off that lead if it goes all the way through. So you have an investment in that right from the start, because if you do your job right, we can convert that into a case that's viable, that can be moved forwards. And then you can actually see that if it weren't for the good work you did, you wouldn't be able to yield the results at the end of it. And so when you start saying these things there is a cost to the work coming in, there is a cost to the job you do, there is a financial stake that you have in this, then I think people start to understand that yes, we are a people-facing service. We work with people. We can't do our job without people. But every single decision within this also has a financial connotation. So as long as you can get that message across to people that this matters, then then you're halfway there. As long as you've got somebody who's thinking about that, then I think that's part of the battle won.
Yeah, you have to respect the revenue, isn't that right? You have to respect your client and you have to respect the revenue. So that would then bring us on to, I mean, a lot of case, we all know that the vast majority of people who make complaints about the health service or whatever, it is that a complaint. It's not duty breach and consequential damage.
Mm.
It's not going to go anywhere. So that says that right up front, you've got to be quite clear as to whether there's chance this thing has legs or not. So what do you do in that initial, when somebody first comes in? If you leave it to juniors, sometimes they don't know. So how do you mentor and oversee and make sure that first connection, that onboarding is solid? Because if that's not solid and you don't do due diligence, just like you do if you're buying a house, you need that due diligence before you get into, all getting it done. So how do you work in those first moments, those first few days where a client contacts you, to decide whether this is viable, it's got legs or not?
Yeah, I think empathy has to be a real skill or a real understanding that people need to bring or need to develop when they work into this particular area. I think that what we would say is that first of all, make people understand that when someone contacts us for a claim for clinical negligence or a complaint against the hospital, people don't go to hospital because they are fit and healthy. People go because they are in a bad state, and they will feel that in their most vulnerable time that they have had a failing. And it's important at that time to allow them to be heard and let them have an opportunity to talk about their experience. And at the first stage, my usual advice to people is let the client, let the person who's contacted you talk, let them explain the situation from their point of view so that they feel that they've had the opportunity to explain where they're coming from and why they feel aggrieved. Once you've got that, then of course, we can go through the more technical questions and drill down. But I think what what you have to get people to understand is that a lot of these people will be with us at a very difficult time. They'll be angry, they'll be upset, which they are right to feel that way. But we also provide a service to the NHS in a way, because if people are complaining to us and coming to us and talking to us about the difficulties that they've had, about the frustrations they've had, part of our role is to ensure that spurious claims aren't brought against the NHS. And I think that you will find that the majority of lawyers who work in clinical negligence have a deep respect for the work done by the NHS. You know, we are strong supporters of the work they do. And if we can make sure that only those claims with merit move forward, then I feel like we're doing our job and our service towards them as well.
Yeah, I think that's very important. It's a balance. Justice is a balance. People say it should be one, and it's not. You rightly said empathy, not sympathy. You can't get angry with them. You can't, with them. I mean, beside them. You can't, get emotional beside them. You've got to have empathy to listen and to try and understand their point of view and let them talk. But you've got to kind of maintain your focus, and I think that was a very well brought out point. So, how is technology getting into this now? I mean, what are you seeing? Our young people today, obviously more than say my age group, are into their technology and especially AI. How are you seeing that starting to influence legal practice?
So AI is a tool, and it is a increasingly more prevalent and more used tool. Um, I'm not adverse to the introduction and to the use of AI within what we do, but I think that there is always an aspect of caution in terms of how we approach it. The AI is only as good as the information it has, and it's only as good as the information that you'll prompt into it. There are ways in which AI can be used right now to shortcut certain processes that we have that I would be comfortable using. For instance, if I have an exceptionally long phone call with a client, provided the client consents to me transcribing the call, I will happily use that transcription, ask the AI to produce, a summary of the call or something like that, so that, it saves me sort of, 10, 15 minutes worth of work in trying to do that. Where I think people need to be very cautious of this is when you start asking AI to go and review certain records or to delve too deeply. What I would say is there are firms out there who are investing very, very heavily in this. All I'd say about those firms is well done to those in terms of getting involved. I think that there is a market for that to be done. And I think those firms who are taking the decision to do that, as long as they sort of, are happy with the results, and as long as that's something that they feel that they are safe to then rely on, them, brilliant. But I think that the smaller firms that may not be able to afford the level of investment, I think you have to be very, very careful with saying, well, we can just throw this through AI, because if you don't have the database sat behind you, if you don't have all of the information, if you're not qualified or trained well enough, it's not something that you can just chuck at it and go, right, that's going to fix that for me. It's a very, very good, but also temperamental tool. So
Yeah,
yes, use it where
it's
you
not so
can.
good at the reasoning.
Mm,
And I mean, I'm involved in teaching AI various things about reasoning and logic, looking at legal cases. But then that leads on to the other part of it, which you're getting heavily involved in, which is the regulatory framework and all
mm,
those background things that are in management, but a
mm.
lawyer needs to be part of. So tell me a bit more about how the legal, you know, management systems are coming in, how the regulatory environment is changing, and what you see for the future.
So APIL, or the Association of Personal Injury Lawyers, have been looking into um, what it is that we should be saying as a group about artificial intelligence. And I believe there are a couple of publications that have either come out or are going to be come out, which give kind of just a generic comment. Um, what I would be saying is in terms of the management and everything like this, yes, by all means, use it where it's appropriate if you feel that it can meet a need. At the moment in time, I would be very, very cautious about relying on any AI for anything that you felt would be particularly serious or needed um needed real input. If we're going to be talking about, um risk assessments for firms, if we're going to be talking about compliance statements for firms, if because you don't know if you put something into, say, any of the AI mediums out there, what you can never be 100% sure of is their source of information, is what they are relying on to bring this forward. So it may be the case that you kind of say, well, okay, draft me a compliance statement for the firm, and it ends up using a source from a different country, which is not correct within the UK law, for instance. Then that could get you into a lot of difficulty. Just as an anecdotal version of this, I asked an AI about fixed costs in clinical negligence, and it came back under the impression that fixed costs were actually already in play in clinical negligence, because it had skimmed a more recent or it skimmed an article which had said they were coming in at this point, but they hadn't. So this is just a very, very small example of how you could say, right, go off and write me this. But if you're not checking the sources, if you're not proofreading, if you're not double checking, then it is very dangerous. So what I would always be saying is yes, use it if you feel comfortable that you can then go and interrogate it.
You need to have that background, and that, I mean, that is very important when you're using AI. It's a tool, but you've just pointed out, for instance, that you can go. I mean, we all know about confirmatory bias. We all have it.
Mm,
And it doesn't have to be AI. You can go and read that article yourself and come out with the same nonsense, because somebody says vaccines are horrible or somebody says vaccines are brilliant. You go and read the articles which back up what you say. And I find that sometimes with lawyers when they're defending a case or where they're being for the plaintiff, they go and look for evidence which backs up what they say, which is right because you are there to advocate for your client. But a medical expert is in the middle. And woe betide any medical expert who starts to do that and assist even in that confirmatory bias. And AI is doing exactly the same. You read whichever newspaper you choose to read, but you choose to read that newspaper because it's biased towards your point of view. I mean, that's the truth. You watch a particular news channel because it's biased towards what you feel. So therefore, you're busy confirming your own problems.
Yeah.
And AI is doing exactly, it's not even that it's new. It's making maybe in sharper focus because AI, if you say AI, go and find me proof of this, it will. Or go and find me proof that this is not true, it will. And that is just the same as a lawyer advocating for this, a plaintiff or the defense. And medical experts in particular need to be very, very careful what they say. And when they're using AI, they need to have that background of experience to be able to say, I've seen this, but there are other things you need to think about. It needs to be a tool, not the way of doing it. So I think that's what else are you seeing in the regular outside of AI? Are you seeing any other stuff coming in to tighten up the regulation on lawyers that young people need to know?
Yeah, so it's still very much in the air at the moment, but there is the Mazur ruling, which was particularly difficult for a lot of colleagues who are ILEX, FILEX legal executives, where I'm not sure if you're aware of the judgment, but there was a query made about who has the ability to conduct proceedings.
Mm-hmm.
Now, for a while, the profession, or in my view, if you are a legal executive, you should be treated just as a solicitor is in terms of your qualifications, your ability to do your job. But the judgment in that through question as to whether or not somebody who wasn't a solicitor could conduct legal proceedings. Now, there is a bit of a background to that case in terms of the individuals involved and whatnot, but it shows the difficulty that we have sometimes, that the profession is subject to change and subject to very quick change, that we have to be very, very quick to react to. I am hopeful, and it's my view that this decision, eventually we will get some guidance from the SRA and from the legal executives governing body that there is no issue, that legal execs can conduct litigation, or at least with the right safeguards, whatever we decide it is, because it has caused a bit of concern in the profession. I think as well as we move into this, as we talked about with the AI, the development of transcription software, the development of sort of being able to summarize documents and stuff like this, there is a concern that those job opportunities for less qualified individuals, people who want to get into the profession, may become more difficult, may become more competitive, because as a firm, you could understand how you could say, well, we could buy a software package for £200 or whatever it would be for the year, or we could employ somebody who, for whatever cost that would be, that you would have to train to do that work. And I think that there does need to be some kind of compliance. What I would like to see is, or what I feel like we will see in the future is especially with AI products, is that hopefully the Law Society will accredit a particular product, or they will regulate a particular product, and that will become what we as lawyers are able to use, because we will have support from the governing body to say, right, this one is fine. We approve the use of this one. It adheres to certain standards, and then we can rely on that. But also, it will take a bit of a logical stance from lawyers that we will still need to employ junior staff, because they're the future of the profession. So we need to ensure that the opportunities are still given to those, so that they have the ability to learn, so they have the ability to come in, and so that they have the ability to progress as well.
Yeah, I think that's very important. We had a sort of when that surgery, when keyhole or laparoscopic surgery came in, we were all brought up doing open surgery, get your hands in to get a gallbladder out, for instance. Then we went to laparoscopic, and as it became more advanced, then the younger ones coming in only learnt laparoscopic surgery and never opened an abdomen. And then when they got in serious trouble during a laparoscopic surgery, they couldn't open up because they'd never done it before. Whereas
Yeah.
those of us that had the background of doing this generality could do the laparoscopic surgery, and if it was a problem, we just opened up and finished it. So you can see that you lose skills when this sort of thing happens, and it's that training. I think it was Franklin a couple of 100 years ago said there are two certainties in life, and that's death and taxes, especially now. I said there were three: death, taxes, and change.
Yeah.
Whatever we do, change is inevitable. And we have to be open to that change. And we have to look at what the positives are and what the pullbacks are, so that we can fill in the weaknesses, because there will always be weaknesses in change.
Yeah.
And there will always be strengths, which is why we'll change in the first place. Mark, this has been a brilliant conversation. I think we've gone over an awful lot from your background, how you've seen regulation evolving, how you've seen yourself move into management, and the understanding that law is a business, and where you're not trying to make stupid profits, you need to be in a profitable basis, and that those coming in need to understand that. And I think a lot of our listeners will get that, because a lot of them are not senior in practice and they don't want to buy a practice, but they've got to understand that if they're not going to put their money where their mouth is in terms of buying a practice, they've still got to be entrepreneurs as opposed to entrepreneurs. They've got to work for that company and help that company survive, because if that company doesn't survive, just the same as happened to you, you're right. Mark, thank you so much for talking to me today. I think that was a fascinating conversation, and I wish you all the best in where you're going in the future.